Again, most of my advocacy stuff stems from a pro se litigant standpoint, and there's sometimes that we're unable to find this information while we're dealing with our own personal cases in family court. And in Harris County, and I've repeatedly said this in this committee several times, is that these judges don't know the bare fundamentals of the law. I mean, they're threatening members of the public and the media with contempt for observing their court proceedings. And so when you have judges that are sitting on that bench threatening the public for observing their courts, to me, that's a big deal, because I go to family court, I go to court to look for justice. And if these judges don't know the bare fundamentals, such as the First Amendment, we can legislate these laws all day long. But to wrap it all up, we have to have a competent, qualified judiciary to follow these transparency laws. But I'm all for it. Again, as a pro se litigant, I see things from a different lens. And, to me, if I see a campaign contribution from a law firm, such as Coons Fuller or somebody of that magnitude towards my judge, the appearance to me, through my perspective, right, I'm just pro se George looking to navigate his way back to his child. The appearance is there. So I appreciate this bill, and thank you for the time.
All right, thank you, Mr. Saldana. Kongwa Arnold Yan, have you here on behalf of yourself registered for the bill? Is that correct?
Yes, I'm for the bill. And,
okay.
Actually, this bill is in line with the Supreme Court ruling. In 2015, Supreme Court has a ruling called William U. Lee versus Florida Bar. In that ruling, Supreme Court said, protect the appearance of judicial integrity and impartiality is without doubt a government interest of highest order. And in that order, the Supreme Court upholding state ban on solicitation of funds by judicial candidates. That's already happened in Florida. And they said the government's long recognized interest is assuring the appearance and of the judiciary uninfluenced by public opinion or pressure. They consider money is public pressure because they believed the respect will elude if the public believe the judge are mainly channel on political will, which is getting the lawyer, and let alone the will of their favorite party. And the liberty can have nothing to fear from the judiciary alone, but will have everything to fear from its union with either of the other departments. And in the federal Constitution, they protected the interest. They said judge is not elected. Judge have lifetime term. Also in the Constitution, federal, they have saying judge have life tenure, which means you don't have to worry about the election. You don't have to worry about the money. But in states, judge get influenced by the campaign. They needed the money. And actually, I have a question for the $3 million issue. I see how family court operates. If both parties' lawyer give the money to the judge, it does not change the outcome of the case. The judge will rule, sell the assets, divide to pay legal fee. Actually, all the political campaign contribution is coming from the legal fee awarded. That's what I can see. I was in the court, and my ex switched a lawyer 1 week before the trial. That lawyer had a fundraising event for the judge. Next day, go to the hearing. The judge rewarded her legal fee incurred in a criminal proceeding when I am the victim. I'm not even a party.
Arnold, I gotta have you wrap up.
Sure. I'm just trying to say, basically, judge will let the lawyer to collect the fee from the fee for whoever pays. So judge become a revenue collector for the lawyer. This is how bad this thing is.
Okay. Thank you, Mr. Yan. Bill Lyle, I'm sorry, Kai, let's go to you. Kai Andrews. Am I saying that right?
Kai Andrews.
Yeah.
You got it, yes.
That's what I thought.
Hawaii,
On behalf of the
Kai.
Children's Court and yourself registered for the bill. Is that correct?
That is correct.
All right.
We're almost there.
Yep.
And I just wanted to say thank you so much. Thank you to Representative Hayes and Representative Moody. I think you brought something up that I would like to kind of touch on as well. And I'll go ahead and move into it. So felt like I've been at church tonight. I actually just wanted to be like, amen to a lot of the things here. I really appreciate you guys. You know, it seems that we're standing up for our rights. So thank you, Chairman Leach and members of the committee. My name is Kai Andrews, and I am the founder of Children's Court, a growing advocacy initiative. I am here today not only as an advocate and an activist, but as someone directly harmed by the judicial practices this bill seeks to address. I support HB 5411, but I do believe it must go a little bit further. This bill, the Trust Act, seeks to protect the integrity of our courts by exposing improper financial ties. But unless it explicitly references Canon 2 of the Texas Code of Judicial Conduct, which bars even the appearance of impropriety, we miss the heart of the issue. In my custody case in the 169th District Court of Bell County, I learned that the judge received the largest campaign contribution of her term from my ex's attorney. She also acknowledged on the record their 30-year working relationship. That same attorney also selected the guardian ad litem with no formal training, someone I strongly objected to, who regularly appears in his cases and she consistently sides with. That's bill for another day. The judge awarded my ex full custody with no justification, despite the fact that I had been my daughter's primary caregiver and was described in court as a wonderful, loving mother with a very strong connection to my daughter. But the court stole that. She then ordered me to pay his legal fees, despite me disclosing over $300,000 in personal losses, even though he had filed his second baseless lawsuit. The facts didn't matter. Her mind was made up, and now I believe we know why. What I experienced is part of a predictable pattern. When a judge's top campaign donor stands before them in court, no reasonable person can believe justice is being served. And I know I'm not alone. Far too many have lived this story, not just in Texas, but across the nation. If a juror or a judge in a criminal case was found to have taken money from a defendant, this is called bribery. A mistrial ensues and felony charges. But in family court, when the same influence flows through campaign contributions, we are told to just accept it. Yet the damage is just as real. So what I propose is 3 additions to this bill: mandatory disclosure of past contributions for the judge's entire term, a presumption of bias when a party or attorney is a major contributor, and a direct reference to Canon 2, so this becomes enforceable ethics, not just compliance. It is a vital step, HB 5411, but to restore true public trust in our courts, we must go beyond donation-driven justice and let this be the beginning of the shift. Thank you.
All right. Kai, thank you. Bill Lyle, Bill, I have you here on behalf of yourself registered for the bill. Is that correct?
That is correct.
All right, go ahead.
My name is Bill Lyle III. I am a father, a Republican, a resident of Collin County, and a lifelong Texan. I am here this evening to help protect the integrity of our civil justice system. I appreciate your important service on this item. At 11:30 a.m. on July 2nd, 2019, I was going down the escalator in the Collin County Courthouse. What had just happened in my hearing was unexplainable, absent the adage, when something doesn't make sense, follow the money. Never believing that a prominent Dallas law firm and a sitting judge would do something that would overtly tarnish the legal system, I vowed to let the sting of this hearing settle, and I waited a year to look at the judge's campaign finance reports. I wanted to see how much the opposing law firm donated to the judge and how often they made donations. The undisputed facts reported by the judge herself are what have me here in front of you all today. The judge issued a notice of hearing on June 24th of 2019, requiring both parties to attend a hearing on July 2nd. The judge reported receiving a campaign pledge of $2,500 on June 30th, 2019. This pledge was made the Sunday before my Tuesday hearing. What came next is amazing. The next report showed that the $2,500 that was promised to the judge on the Sunday before the Tuesday hearing became money in the judge's account on Tuesday, July 2nd, the day of our hearing. These facts create a complete erosion of the impartiality of our courts. Justice should not be for sale in Texas. The bill before you is a small step towards creating a better system to allow support for our judges and not erode the paramount importance of impartiality. Following this discovery, I did 3 things. I paid for a half-page ad in the Dallas Morning News. I took the facts to the elders of the church that the attorney attended, and I turned the facts in to the Judicial Ethics Commission. If you would like the outcome of any of these actions, I'm available for questions.
Thank you, Mr. Lyle. Appreciate it. Members, any questions for this panel of witnesses? All right, thank you.
I do also have paper for everyone for the suggestions if you would like a copy.
Santana, Taryn Champagne, and J.R. Woolley. J.R., the chair will show J.R. Woolley registered on the bill but wishing not to testify. Taryn Champagne, I have you here on behalf of yourself registered for the bill. Is that correct?
That is correct, sir.
All right, go ahead.
My name is Terrence Champagne, and I'm testifying in favor of the bill. Pretty simple, as Ms. Andrews noted, right? We've got the judicial canons, Canon 2, avoiding impropriety in the appearance of impropriety in all judges' activities. This simply allows the litigant the opportunity, if they feel that there's a potential for impropriety due to these contributions, to recuse the judge or, attempt to recuse the judge, or allow the judge to do the potentially honorable thing and recuse themselves. I don't know how many of you have ever tried to look up campaign finance information on the Texas Ethics Commission website. It is incredibly complicated, and you really need to work pretty hard to figure it out if you're a layman or, for example, a pro se litigant, which I think you've heard quite a bit from. Other than that, I think it's a great bill, really helps protect individuals and help increase the trust the public has in the judiciary, which has really has taken a beating this legislative session, considering the amount of bills related to judicial accountability. And with that, I'll conclude my testimony.
All right, thank you, Mr. Champagne. Chair calls, is it no Santana?
No.
Okay, registered for the bill, is that correct?
Yes.
Thank you.
Distinguished representatives, Honorable Chairman Leach, you have before you the reason that we are all here tonight. If you go to the very first page, this will be the page. Judge Linda Dunson, we had a hearing in her courtroom on January the 4th, 2019. Our case was reset about 10 days down the road, and when we returned, we received our trial setting. The the Facebook announcement that you see on the very first page was placed by Judge Dunson on her Facebook page. The fundraiser was held literally like 3 or 4 days later at Julie Ketterman, the opposing counsel's office. On January the 24th, 2019, Julie Ketterman raised over $16,000 for the judge who announced the fundraiser on the same day that we received that she posted it on her Facebook page on the day we received our trial date. The 3 supporting documents right after that is from the Texas Ethics Commission, reflecting the contributions made, 4 pages made at the law office of Julie Ketterman. And on the very last page is a Texas Ethics Commission report. Report number is 100052342. And that indicates that on the same day as the fundraiser, Judge Dunson wrote 2 checks to Julie Ketterman for almost $3,000 for expenses. Now, the next, this is Texas Election Code, and the Honorable Representative Moody. This is for you. Texas Election Code Section 253.153 states 120 days after an election, which in this case was March the 6th, a judge can no longer accept any campaign monies, period. End of story. If you go on to the next page of that, the Honorable Judge Dunson returned $500 in the same TEC report to Attorney David Romero on March the 12th, 6 days after that, showing that she acknowledged. And the reason that she put returned, she said, return to donor, donation received after contribution period. Now,
All right, I
if
gotta have you get to a stopping point, if you will.
Okay,
We've still got a lot of
okay,
bills to hear.
hang on real quick. The very next page, Judge
You got 30
Dunson.
seconds, go.
Judge Dunson shows a $290.30 campaign expenditure to GoFundMe, disguised a $10,000 campaign, anonymous campaign contribution that she reported to the Texas Ethics Commission, $10,000 in cash 3 days before the trial. The Monday of the trial, which was March the 18th, Judge Dunson received hundreds of dollars daily, and that report is there. She received an additional $4,000. The month following the trial,
I think we
on
get the point. I think we
Okay,
understand.
she accepted $30,320 before, during, and after the trial.
Okay. Okay.
Now-
I think we understand. Members, are there any questions?
Okay.
Ms. Chantel, we've got to go on. We've got other witnesses
Okay,
who are behind you.
please allow me to introduce the Texas Ethics Commission, the Judicial Commission,
We have
and
all
the
the,
State
we
Bar.
have all of the information that you've given us. I've looked at it. I see the members looking at it as well, and we appreciate your testimony. Say it again? Well, we have it. You handed it out. There's copies for all of us up here. We appreciate it. It's very helpful. So thank you for your testimony. Does anyone else wish to testify on, for, or against? Yes, thank you, guys. You're excused.
Is there any
Thank you.
questions?
No, I don't have any questions. Members, any questions? No. Does anyone else wish to testify on, for, or against House Bill 5411? Seeing none, the chair will call on or recognize Representative Hayes to explain or close on the bill.
Thank you, Mr. Chairman, and thank all the witnesses who testified. Thank you, Mr. Santana. We do appreciate your handout. I'm not used to having a bill where everybody's in favor of it. I'll close.
Yeah, I mean, it's